Microphone was not on. Thank you. The red light is not on either. Okay. So now that the red light is on, we're broadcasting. For the record, this call to order the meeting of the Montana Public Service Commission meeting here in the Bollinger Room in Helena, Montana. The date is December 10, 2024, and the meeting is called to order. The first order of business is there any public comment today? No public comment in the room or online. Okay, so we'll proceed to the first order of the action items. That's approval of the commission minutes for the week of November 25, 2024. Is there a motion?
I'll move to adopt the draft minutes of the final minutes of the meeting.
I'll second.
Okay, it's been moved and seconded. Any comment on that? Okay, let's call for a vote on that. All those in favor of Commissioner Brown's motion to approve the minutes, say aye.
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 No? I would mention now that we're full here that Commissioner Brown and Commissioner Pinocci and Commissioner Bukacek and Vice President Fielder are with us today. So we do have a quorum on there. So moving now on to work session items. The first item is 2021-12-136, Quest Corporation DBA CenturyLink, the Commission's investigation into the adequacy of legacy infrastructure operated by Quest Corporation DBA CenturyLink QC to consider approving a joint stipulation and settlement agreement. And we have a bunch of staff here to give us who is the lead on this. Mr. Polko.
Chair O'Donnell, Commissioners, this matter was last before you at the November 6, 2024 business meeting. At that meeting, the Commission deferred making a decision because there were questions about some details of the joint settlement and stipulation. Before you today is amended joint settlement and stipulation agreement. That agreement was amended to clarify that the financial subsidy would be provided by check. Also, for clarification, while it wasn't part of an amendment, at the November 6th business meeting, we were also asked to clarify about who would be eligible for the subsidy. The subsidy is offered on a service address basis to any customer served by Anaconda or Go Digital. So it would be a service address basis to receive the financial subsidy. As a reminder, I'll just go over a few of the main provisions of the settlement agreement. First, there's a financial offer where CenturyLink and Commission staff agreed that CenturyLink will offer existing customers served by Anaconda or Go Digital facilities $3,000. Again, and that is by check now. Also, there's a modification of the metrics to measure CenturyLink service quality. In the settlement, Commission staff and CenturyLink agreed that Montana Administrative Rule 38.5.33717B will be waived for a period of 3 years and replaced with the metrics described in subpart 3B in the settlement. Those metrics go over a mean time to repair. It goes over a provision measuring long outages, and it has a long outage maximum. That, as a reminder, that long outage maximum is if out of service trouble report is not cleared within 720 hours. With some exceptions, customers will be offered the financial subsidy, as mentioned for the current Anaconda Go Digital customers. The settlement also adds a new metric concerning how CenturyLink meets its repair commitments, and that is in subpart 3D. The settlement requires comprehensive reporting in addition to the reporting required by Final Order 7825K, which was the final order in this docket that we issued quite some time ago and have been getting some reporting as well. The Commission approves the settlement. The Commission will issue an order memorializing its approval. Staff recommends that the Commission approve the settlement. As a reminder of the procedural posture of this docket, there still remains an outstanding motion for reconsideration by CenturyLink. The Commission votes for staff's recommendation to approve the settlement and issue an order approving the settlement. There would be an order to approve the settlement. However, if the commission does not approve the settlement, the commission will still have to consider the motion for reconsideration at a future business meeting. Again, staff recommends that the commission approve the settlement and direct staff to memorialize approval of the settlement in an order. Questions?
Well, I would just add, Mr. Chairman, that one of the things inherent in underlying disagreement is our hope from a staff standpoint, which I think was expressed also, and also shared by the commission, that assuming the legislature takes some action to modernize Montana's telecommunication laws this legislative session during the 69th legislature, that the commission will then have an opportunity, I think, to modernize its telecommunication rules, which is something that I think is in it's time to reconsider all of our telecommunications rules as they relate to CenturyLink and other providers in this state, so that we can have a more modern regulatory and statutory infrastructure for telecommunications companies in which they can operate and we can successfully regulate them.
Thank you. Additional comment? No. Thank you. Question? Any commissioner? Commissioner Brown?
Mr. Chairman, thank you. Gentlemen, thank you for your presentation this morning. I'm pleased that we are back here to consider this matter. I do have some questions for you prior to us voting on this matter. As you know, we sent this settlement out to interested parties. We have received public comment or feedback regarding the same. Three questions, I think, that were thematic in terms of the public comment on this that I'll have you address. Certainly, Vice President Fielder brought up during last consideration of this matter whether the form of remuneration to the customer needed to be addressed and how that remuneration be handled. Can you address that matter?
President Brown, commissioners, that matter has been addressed in the amended settlement agreement. The remuneration will be by check for the $3,000 subsidy offer.
All right, thank you. Mr. Sanders, do you want to address that at all?
Well, I just wanted to add that I think, and Vice President Fielder can correct me if I'm misstating her concern, but one of the concerns was that some of these remunerations might come through gift card, which I think is a very often used mechanism by a lot of companies in terms of providing rebates and other forms of remuneration to their customers. In this case, we figured that by check would be much more certain to arrive at its destination and not be sidetracked or used in some other way, so that I think this is the resolution that that the customers were seeking and that the commission was seeking. And so I'm very happy with how CenturyLink agreed to that provision.
All right. Mr. President, followed. Certainly, we received some comment or feedback from folks that had made comment as to the adequacy of the services provided by CenturyLink over time. Some of those folks indicated to us through their public comments as to this proposed settlement agreement that they questioned whether or not this should have retroactive application to those customers that were of CenturyLink that were still customers at the time that we opened this docket in 2021, I believe, but are no longer customers. Does this agreement address that, or what is the circumstance or answer for those folks that commented on that topic?
President Brown, Chair O'Donnell, commissioners, the settlement only is a forward-looking settlement. So it'd be to assist the customers who are still currently being served by the Anaconda or Go Digital lines. And it provides maximum consumer choice for the existing consumers who are still on the Anaconda and Go Digital facilities.
So to follow up, Mr. President, so on that topic, would it be appropriate to have bargained for a retroactive application of this settlement for those persons who were no longer customers so that they were included?
President Brown, Chair O'Donnell, Commissioners, certainly that could have been a possibility. However, in order to define the universe of individuals who are still receiving service and that to give them the consumer choice now, customers may have always had consumer choice within any of the service areas served by Anaconda or Go Digital or CenturyLink in general. We were looking to find resolution for those consumers who are still seeking to use their consumer choice to move off of the services.
Mr. Sanders.
If I could add, Mr. President, it seems like, as you know, the ability to exercise consumer choice in this case varies from location to location, customer to customer, and their relative desires to move off of that service. So a lot of previous customers who had these problems have moved off. They've either moved to cellular or to satellite or to some other type of system already. And so they did that. It was easier for some of them. I think the customers that we're dealing with now is that group where it's very, very difficult and few alternatives remain for them. They may be several miles from cellular service or something like that. And so what we're seeking for them is actually a better sort of next generation solution. And that's sort of how we arrived at this potential solution and the relatively high number. In fact, more than twice what CenturyLink's original offer was, so that they could move to even a satellite-based system so that they'd have coverage really regardless of where they were in the state of Montana.
All right, follow up.
Please.
So, as you know, we also received public comment and questions relating to what happens to a customer that has multiple lines with CenturyLink. How is that addressed?
President Brown, Chair O'Donnell, Commissioners, it all depends on whether they have multiple service addresses. So the service address is going to be the key issue here. We will, if the settlement is approved and we have a order approving the settlement, that order will require reporting where we will have an exact list of all the customers eligible, as well as that is subject to a protective order. That information partially is subject to a protective order, so we'll have also a redacted version publicly available online for individuals to fully understand if, depending on how many service addresses they have, how much compensation they'd receive.
All right, thank you. I'd say one of the more compelling lines of comment that we received was from those folks, as you alluded to, Mr. Sanders, that there are portions of this state where modern telecommunications have not been provided, which is truly remarkable in the year 2024, considering that, in the 1930s and 40s, we made it a priority in this country to modernize the communication system, and we're able to do so successfully. And here we are in 2024, where we have multiple areas of Montana that are underserved. So for those folks that commented to us that perhaps these legacy telephone systems are the only form of communication they have access to, what protections are built into this settlement agreement to ensure that CenturyLink maintains quality of service. You could address that, Mr. Poco.
President Brown, Chair O'Donnell, Commissioners, in subpart 3 of the settlement, there's a service quality plan that still maintains service quality requirements, both as I mentioned, on a short term and within 72 hours, in a called midterm within 240 hours, and within long term within 720 hours. In particular, for customers who aren't directly eligible for the subsidy, who aren't served by any kind of Go Digital, and are experiencing long outages. The long outage maximum provision provides those customers to be eligible for the subsidy if they experience such a long outage, thus allowing, again, for maximum customer choice, even for those who may not be directly served by any kind of Go Digital at this current moment. That offer is good for any customer experiencing those long outages.
Follow up. So certainly one of the things that I think this commission has been concerned about in addressing the original request by CenturyLink for the waiver of the service quality rules is that we have seen over time where CenturyLink customers have averred repeatedly that CenturyLink hasn't met our own requirements for service quality, correct?
President Brown, that is correct.
So it's my understanding that if this settlement is approved, we are still maintaining service of quality requirements, correct?
President Brown, correct.
But as I understand from the settlement agreement, what CenturyLink was seeking was a 6-year waiver. Is that correct?
President Brown, originally CenturyLink was seeking a 6-year waiver of the out of service rule, which is Montana Administrative Rule 38.5.33717B. That was within the underlying proceeding where the commission rejected that in its initial proposal through the final order in this docket. However, now there are still service quality requirements to comply with out of service trouble reports and clearing those out of service trouble reports within a certain period of time.
All right. Mr. President, I'm going to support the motion to adopt the settlement agreement today. I would just note for the commission's understanding and for the staff's understanding that in paragraph 4 of the joint stipulation and settlement agreement, which encourages the commission to commence a docket to modernize the telecommunication rules. It recognizes the highly competitive intermodal and modal and ever-evolving nature of today's telecommunication market. I would just note that the commission, while I was on it in 2021, and specifically in docket number 2021.10.125, has already opened a docket to investigate the modernization of telecommunications regulations. So I just suggest that we fold this matter or utilize that existing docket to satisfy that paragraph. Mr. President, thank you.
Thank you. Is there a second to the motion?
I didn't hear a motion yet.
Oh, I thought you made a motion.
I thought you made the motion.
There's been no motion yet.
Oh, that's it. Do you wish to make a motion?
Well, I thought you were going to make the motion.
No, I'm not.
I will move
Okay.
to adopt staff recommendation and to approve the joint stipulation and settlement agreement and instruct staff to draft the final order memorializing the approval of the agreement.
I'll second your motion.
Okay. Any other discussion? Commissioner Pinocchio?
Thank you, Commissioner O'Donnell. So let's say a person had some trouble with CenturyLink a few years back. This problem's been going on for a long time. They didn't get service. They continued to pay. They didn't get service, but they had to move out of state, say 6 months ago. Will they get compensation being that they had to move and they've been gone for a while, but they had to deal and experience these problems and pay a bill where they didn't have phone service. What's the answer to that?
Commissioner Pinochi, those customers would not be eligible for the $3,000 subsidy at this point. It's for the existing customers on the Anaconda and Go Digital services. However, generally speaking, as noted in subpart 3F, customers have always had the opportunity to reach out to CenturyLink to receive customer credits on their bills for service that they didn't receive.
Some didn't get that. That was one of the complaints. And not one, several. I do have to get some questions out because this has been a long-going process. I've had complaints from one end of the state to the other, and I'm going to have to be able to answer to my constituents to say, even though you paid the bill and didn't get service, and of course you had to leave for whatever reason, you had to move, and now we've come to this settlement agreement, you're not going to get any compensation. It's just fair so I know the rules, okay? There are people that paid for their service, didn't have any service, and then had to move to another provider because they couldn't get service. And they'll say, how do I get that money back? And the answer to them is no, there won't be any money for them. And then they'll say, maybe you could have got us a better deal, Pinochi. What kind of answer do I give them for that?
Well, Commissioner Pinochi, if I may, I think you're absolutely right about the problems that we've even just the information that we've received here at the Public Service Commission through our regulatory compliance and customer and consumer assistance staff here. There have been dozens upon dozens, perhaps hundreds of these complaints over the last several years. And our staff has assisted those people in trying to get resolution of those problems, billing issues and other things from CenturyLink, and with some success over the years. In terms of this agreement, we really could only address things that rather than going case by case throughout hundreds of consumer complaints over several years, this only addresses things looking forward. Okay, so what we were trying to do was come up with an agreement which gets the best possible deal for consumers going forwards and get some certainty for CenturyLink in terms of what the expectations are for the amount of service that they will provide and the conditions under which they will provide it. And so I think what we have now is a situation that's much better than we had before. I think you're absolutely right. A number of customers have already, what's the phrase, voted with their feet and moved on to other services or moved on to other jurisdictions where they could get better service. But in this case, I think that all we could realistically do with this agreement was do something that took care of the problems going forward rather than trying to re-examine everything going back in history.
Although I sure want to recognize staff's good work here, but I also have to explain that some of my constituents that have made complaints are not understanding a few things. For one, they believe that CenturyLink took millions of dollars of federal money to make improvements, and they don't believe they made the improvements, and they want to know what happened to their money. That's a fair question, and I'd like to have an answer for that. And I know that you may not have one. And then, of course, my constituents that paid their bill, while this office said to continue to pay their bill even though they didn't have service because they didn't want to damage their credit, then they had to move, or finally they had to have phone service, so that they left for another phone service, and they've lost their money and they'd like to be able to get that back. And I guess the answer to that is no. So I want them to understand that I asked those questions, but I do agree that you guys have gotten a good deal, and I'm glad that we've done something. But I would encourage and will encourage the public to continue to ask questions to what happened to the millions of dollars CenturyLink was given to make improvements. And their answer is, we have old antiquated equipment and we can't get spare parts for it. That's what the millions of dollars of federal money was supposed to replace. What did you do with that money? Okay. So these are fair questions that I think continue. And I will encourage my constituents to further ask about that. Thank you. No more questions.
Thank you. Commissioner Fielder, any
Thank
questions?
you. I do. A couple comments and questions. Thank you, Mr. Chairman. Thank you to the staff's work to fine tune this stipulation agreement a little bit to address some of the concerns I had with the prior draft. Can you just explain to me the service address basis that it's not in the settlement agreement, but the staff explained it, or Mr. Pokel explained it at the beginning of his commentary. So can you just flesh that out for me? So, and for potential customers that may be listening, what exactly does that mean? Who will be receiving a compensatory check to move off of the service, or who will be eligible to receive that?
Vice President Fielder, Commissioners. So the service address means the address actually served by the Anaconda Go Digital equipment. So I think generally you can have a very different billing address comparatively to where you're served. So the service address directly ties to receiving service by those legacy infrastructure. So thus we're using service address as the qualifier to receive the financial subsidy. So if you have, a business at one service address and you use CenturyLink there, and then you have a residence at a different service address, because the service addresses are different, I believe you'd qualify because you'd have two separate service addresses.
Okay, so if you have a business at your home and you have an account for your business at that service address, that's one service address. And if you have a private line, a different account at that same address for your personal use, you have two accounts at one service address. So this subsidy would go to who? The business or the resident at that service address?
Vice President Fielder, I mean, for all intents and purposes, I believe it would be the same. I mean, it would go to just one payment per service address. So if you had a business in your home, it would go cover that service address as a whole, even if you have multiple different accounts within there.
Yeah, I mean, there may not be too many situations where this is an issue. Maybe there's none that this is an issue, but it would be an issue because, when there's a business entity at an address and then there's a residence at the address, they're not one and the same. They're two different persons under the law. So that might be something that comes up that we'll have to deal with. So I guess, I don't want to hold this up over that, but I think we need to look into that further and try to proactively determine how that will be handled. And then I'd like to say that I'm appreciative of the terms and condition paragraph 1 or point 1 and part A, where it stipulates that CenturyLink will create a dedicated toll-free number specifically for use by eligible customers to explore and seek information. Goes into my first comment here, but also, for those customers who want to explore other options of service, I hope this will be a robust array of information for them to get that information. And I'd like to know from staff, do you have plans to follow up and monitor how that's going to make sure that, we're trying to ensure the company is accommodating as smooth of a transition as possible? Because I think it's going to be kind of a rather large inconvenience for some of these folks to move off the service, but I think it's going to be worth their while to do it, to go to better service. So what would be our role as an agency in keeping an eye on how that's going?
Vice President Fielder, if I may, I think one of the things that it was inherent in designing this part of the settlement agreement was that we would be monitoring this very aggressively and holding CenturyLink's feet to the fire in terms of the actual implementation of this information system. And our regulatory compliance and consumer assistance staff will be in tune with them and working hand in glove so we can continue to monitor this. We did build in a number of additional monitoring provisions in terms of their service quality, and in terms of how this part, because this is a unique part of the agreement, will be implemented. So we need to make sure that everybody gets the right information, that they're getting it in a timely fashion, that that we try to root out, and I'm not suggesting for a minute that anybody would be playing games with this kind of a settlement, but that to make sure that the system isn't being gamed by anyone, either CenturyLink or its customers, in terms of having this agreement go forward. The idea here is to get a resolution of these long-standing problems that have plagued this network and this legacy system, and try to modernize it and move it sort of from the 19th into the 21st century. So we will be monitoring this very closely, and I'll be working with our staff on that, as will Dan and our two telecommunications experts on staff, Mike Dalton and Mike Sheard, who is also a part of that regulatory compliance and consumer assistance staff, and as you know, is a true and genuine bulldog on these issues and trying to protect Montana's customers.
Good. I'm glad to hear that. Thank you. And I guess just my final remark here is that going back to this scenario where there might be a home business running out of a service address, it's been my experience in operating a home business that I can have a service like a Starlink, which is very reliable, and either my business can pay for that service, or I as an individual can pay for it and then bill my business for that portion that the business uses. So I think the individual service address solution here is workable. It's going to take some, like I say, it's going to be some inconvenience for the people that are affected by this, but I think this settlement agreement and the $3,000 compensation is far, far better than the original proposal that the company had brought to the commission several months ago. So I appreciate the good work that's been done to negotiate a better deal for the customers, and I think we've arrived at that, and I'm happy to support the motion today.
Thank you, Vice President Fielder. Commissioner Dr. Bukacek? Questions? Okay, thank you. I would like to follow up on some of the comments on Mr. Sanders in terms of this commission has been, I will not say overly generous, but quite generous in their dealings with CenturyLink. As it's been said before, this problem has been going on for a very long time. It seems to me that we have been hampered by commission rules that are out of date, because being a creature of the legislature, the legislature has not updated its telephony laws on this. Would you expand upon that a little bit? How the legislature can make this better, and then how it makes our job more workable?
Well, Chair O'Donnell, far be it from me to be critical of any member of the Montana legislature or the group as a whole, but I would say that it is, the telecommunications industry has evolved very rapidly, and that the pace at which it evolves seems to only accelerate with each passing year, for that matter, each passing month. And so to the extent, and, you know, we know that our legislature only meets in regular session every 2 years. And so it's difficult to keep pace with an industry that is advancing at a much faster pace than that. So there's challenges there. And in fairness to the legislature, they just haven't had a chance to really have a comprehensive look at this, and it would probably take more than the length of a legislative session to give it the look that it needs, especially when, you know, as we know, the committee that of jurisdiction, at least from an authorizing standpoint, there also deals with energy issues, which also has been a very rapidly you know, technologically and from a regulatory standpoint, that industry's been evolving very rapidly. So it's hard for the legislature to keep pace. And we can only do what the legislature, we, the commission, speaking as your designated executive director, we can only do what the legislature allows. But having said that, we should probably, you know, I think it's great that this commission in particular in the last several years has opened this docket to look at modernization, as President Brown correctly pointed out. I think this commission has done a remarkable job of staying in touch with customers who are served or underserved by various services and telecommunications services in this state. We certainly get weekly updates on what consumers are saying and what the public is commenting here. And I know all of you read those comments and take them to heart and follow up on them. So I think we're doing everything we can right now, but I think more needs to be done. And so that's hopefully the legislature will take up some telecommunications and telephony modernization legislation this year. If they don't, I think we still should utilize the docket that President Brown helped set up and that this commission approved of to go ahead and look at doing everything we can do to modernize our rules within our statutory framework. And that's an absolute, must be a top priority of the next commission, I believe.
I quite agree. Mr. Polko, would you characterize the the responses that we've gotten on this, the comments from legislators as well as members of the affected public?
Chair O'Donnell, certainly. There was about 10 comments since the commission last sent notice of the agreement. However, there was lots of comments prior. So the commission previously solicited comments as well around the original proposal in the Montana Consumer Council's alternative proposal, which was to require CenturyLink to go after the BEAD funding, one of the state and federal funding programs. Generally speaking, on the first round of comments, they suggested that the $1,500 was inadequate. I believe the commission, through its final order, agreed that the $1,500 subsidy originally proposed was inadequate. There's still some discussion of the adequacy of the funds. Generally speaking, in the newest round of comments that were provided to the commission after the latest solicitation. However, as Executive Director Sanders mentioned, we believe that the $3,000 subsidy will provide, depending on what alternative service they seek, at least a year and a half, more likely close to 2, even on the highest end of service, and for which would be a Starlink or a comparable satellite service. And in other instances, it would provide even longer amounts of service subsidy. So in terms of the dollar amount, that I just wanted to address that. There were also just generally some other comments that I believe President Brown summarized that discussed, the asking about who would be eligible for the subsidy and if people in the past, as Commissioner O'Donnell brought up, would also receive any kind of compensation or subsidy offer. Well, that was the general tone and tenor of the latest round.
I was looking for more specificity on that. I believe the Webo County Commissioners, who were one of the people who lobbied us to address this issue, that they were, as I understand it, in support of this agreement. Is that correct?
I wouldn't want to characterize the county commissioners' comments, but I have had numerous conversations with them, and I think it's fair to say that they viewed this to be as a definite step in the right direction. But with any sort of settlement agreement, the proof will be in the pudding in terms of how this gets implemented and what happens going forward. So I feel confident that we've done our best to negotiate a good settlement for people living in Webo County and other rural areas that have been underserved by this Anaconda Go Digital legacy system, and that we can help give them a way to sort of a boost to get a more modern and more effective telecommunications system that'll guarantee them the ability to be able to call 911, to call their neighbors, to call their family members, to reach out to whoever they need to in their communities through more advanced technology than a copper wire running into their house.
And I quite agree. And my feeling on this has to do with exactly what you spoke about. I think it is the obligation of the state of Montana, partially of this commission, partially the Broadband Commission, partially the legislature. I mean, it's all over the place. It's not just ours. But I think that the people of the state of Montana need to, except for the people who are, they talk about the last mile. Well, in Montana, it's the last 40 miles, 50 miles. So I'm not suggesting that every single place be connected. But certainly in this case, the number of affected, malaffected customers of CenturyLink are within reach of fiber. And to me, I agree that the goal of the state and all the agencies involved should be the reliable provision of access to 911 at the very, very minimum. That's the minimum threshold. Again, I agree with other commissioners that I really appreciate the work that staff has done, the best possible solution to this thing. However, I will oppose this settlement because I do not feel that it is a complete resolution to the problem. This commission has been, I don't want to say overly generous, but greatly generous to CenturyLink in the face of all these problems, and that we have not really exercised our authority to levy fines or any of that nature or orders to them. But CenturyLink, on the other hand, to me, has been not just reluctant or recalcitrant. To me, they have been an absolute refusal to address this problem, and for a number of excuses on their part. I find that to be unacceptable. And I wish that future commissions, of which I will not be a part, or the legislature, of which I will also not be a part, will really dedicate themselves to solving this problem, which I think can only be solved by making sure that fiber is laid to these particular communities. So at any rate, any other points? President Brown?
Thank you, Mr. Chairman. I'd just like to elucidate some actions that this commission has taken in the last 3 years in regard to telecommunications, just for public knowledge and frankly for knowledge of the commission. So as discussed in 2021, this commission did open a telecommunications station docket, when as part of that took comment on what could be done to modernize telecommunications in Montana. As a result of that docket, as you know, the Commission ran a telecommunication modernization bill during the 2023 session. Unfortunately, that bill was killed in the Senate of the legislature. So I would just like to note that this commission has taken action legislatively to try to address some of these problems. We did not get support from the legislature on that. The second thing, and this is a question for you, Mr. Sheard. As you know, Mr. Sheard, the Montana Consumer Council has filed testimony in the underlying docket in this matter, wherein one of their suggestion was to have the commission require CenturyLink to apply for BEAD funding. Is that correct?
Commissioner Brown, that is correct.
Could you tell us what the status is of the allocation of the BEAD funding?
You know, my understanding is the application window is open. And, you know, I was going to listen in on a meeting the other day of the Broadband Commission, but it was postponed. So I'll have to get back to that when they have a meeting to get more up-to-date information. But, you know, I have high hopes for the outcome of that. I hope that the benefit of all this federal funding extends to these pockets of CenturyLink customers, whether it's CenturyLink going after that money and spending it and putting fiber in, or somebody else. They're between the BEAD money and a previous program, ARPA money, there's almost $1 billion coming to the state of Montana to deploy broadband. You know, we're talking more about voice with this docket, but it's really broadband is the name of the game nowadays. And then there's other programs, federal funding programs. There's more than $1 billion coming to the state of Montana. And some of this has already come in and it's starting to, you know, I think there's fiber projects underway right now. We all see it when we see the roads all marked up. And, you know, I know in Helena, we have multiple companies doing all kinds of fiber projects. I hope that gets to the, you know, rural areas too. So I think, you know, the BEAD program, which is 628 million, I believe, something like that, is just now starting to, you know, companies are submitting applications and proposals on how to use that money to get fiber to people in Montana.
So building on that, certainly, I think you've heard from all the commissioners who have spoken today that there is some disbelief, perhaps, and disappointment that areas of Montana are basically in a telecommunications wasteland in the year 2024. And to that end, did the commission not submit a letter to the Broadband Commission on behalf of those that have commented to the commission as to that wasteland, I will call it, urging the Broadband Commission to look at and ensure that underserved areas of Montana have access to modernized telecommunications?
That's correct.
All right. Well, I would just note for the public's information and for the commissioners, just to remind you that we have provided public comment to the Broadband Commission, asking them to, when they're looking to allocate this BEAD funding, to make sure that rural parts of Montana are not left behind, and particularly those that receive services from CenturyLink. Thank you, Mr. President, or Mr. Chairman.
Thank you, Mr. President. I appreciate those comments. Very, very, very timely comments. Any other comments? Okay. Let's call for a vote on this issue then. There is a motion on the floor by Commissioner Brown and seconded by Commissioner Fielder. All those in favor say aye.
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 All those in favor, no. I'm saying all those in favor say no. I'm saying no. Okay, for the record. Okay, so the motion is adopted 4-1. And we'll move on now to the second item on the agenda today, which is docket number 2023-07-064, to consider a decision on a stay order of 7980H. Ms. Webster.
Good morning, Commissioners. My name is Amanda Webster, and I'm a staff attorney with the Department of Public Service Regulation. As you know, the draft order before you concerns MT Roll-Offs LLC's application for Class D Motor Carrier Certificate of Public Convenience and Necessity, which was protested by Allied Waste Service of North America LLC and Mackenzie Disposal Inc., which all collectively refer to as the protestants. The Commission held a 3-day hearing on the application in mid-April 2024, and on October 24th, 2024, the Commission issued Final Order 7980H, approving MT Roll-Off's application to provide construction roll-off service in Yellowstone, Carbon, Stillwater, Musselshell, and Golden Valley counties. On November 4th, 2024, protestants filed a motion for reconsideration of Order 7980H and a motion to stay. Staff's recommendation today is limited to protestants' requests to stay the final order while the motion for reconsideration is pending. To summarize, the Commission has significant discretion to stay its own orders. Previously, the Commission has considered whether a stay is reasonably necessary to prevent imminent harm to the public. Protestants assert that if MT Roll-Off succeeds in drawing protestants' customers away, imminent harm to protestants' businesses will result. Protestants also argue that if MT Roll-Off's authority is ultimately revoked on reconsideration, it will create public confusion and dissatisfaction with the Class D garbage hauling industry. Accordingly, staff recommends that the Commission deny protestants' motion to stay, as outlined in the draft order, because there is no clear indication that actual harm will result to the protestants or to the public interest while the motion for reconsideration is pending. I would now be happy to answer any questions about the recommendation and the draft order at this time. Thank you.
Commissioners, any questions? Okay. Thank you. I think that the order is well written. Thank you for your choice words on that. Yeah, I do have in support of the motion. Sir?
Mr. Chairman, in order to avoid the confusion that we had last time, would Mr. Chairman like to make a motion?
Yes. I will move that we adopt staff's recommendation on this docket item.
A second.
Thank you. Point very well taken. I appreciate that. In protestants' letter asking for motion asking for this stay, you know, it says in the absence of a stay, protestants will suffer irreparable harm in the form of lost goodwill, lost sales, customer confusion, and other market-based injuries. And then it says if a stay is not granted and MT Roll-Offs begins the process of operating under a Class D certificate, Republic and Mackenzie will suffer substantial harm, which is different from irreparable harm, I might add. Substantial harm that may force them to cut service areas, increase rates, terminate employees, or reduce employees' hours. I find that their statement originally that asking us to revoke their authority in total has to do with their gross inadequacy of providing services. And yet at the same time, they're saying if we allow them to operate, that they will cause substantial and irrevocable major harm to the current certificate holders. I find that to be really interesting. May force them to cut services, increase, terminate employees, or reduce employees' hours. It would seem to me that this was, it was referred to earlier as customers using their feet to vote, in that the only way that they also say that there's no, that they have not demonstrated any public need. Well, if there's no public need for it, then certainly customers would not be going to this new company. I find that their arguments are circuitous and contradictory on the whole thing. So I think that the motion to refused their application to stay is quite in order. Any other comments? President Brown?
Mr. Chairman. So, Ms. Webster, I guess a legal question for you. So it's my understanding, reading through the proposed order prepared by staff on this, that the traditional elements associated with granting the stay, which is essentially a four-part test, does not apply based on commission precedent. Is that correct?
President Brown, that is correct. And if I might add a clarification there, the four-part standard comes from the statute on a preliminary injunction. Specifically, MAPA discusses a stay when a judicial review is pending. Here, a judicial review is not pending. So we look to commission precedent to see how the commission has dealt with staying its own orders in the past.
All right, and walk me through the two elements that you aver that the commission has adopted for deciding a stay.
In this instance, staff recommends that there are two elements the commission consider in deciding the motion to stay. The first is whether it's reasonably necessary for the stay to prevent imminent harm to the, I think I said substantial harm to the protestants. We're looking at the harm to the protestants. Is something very bad going to happen to the existing motor carriers in the service area? And the second consideration would be whether a stay is reasonably necessary to prevent imminent harm to the public interest.
All right, so is it your legal position then that the stated purpose of injunctive relief, such as granting a stay, which is to maintain the status quo pending the final outcome of a controversy, does not apply at this stage of these proceedings?
President Brown, in my review of the applicable law, a stay and an injunction are slightly different. A stay is typically a pause pending an appeal, whereas an injunction is an affirmative action by a court or a body granting relief that has been withheld by lower courts. Here, we're just talking about the commission's stay of its own order. I think the commission could very well consider equity and the status quo in deciding on a motion to stay. But in this instance, I do not think maintaining the status quo has been a part of the commission's consideration previously when it has dealt with a motion to stay, and should not be a consideration in this instance.
All right, and then I just want to make sure I completely understand what the request is here. I understand that the request is pretty limited in scope, and it's requesting a stay pending the outcome of the motion for reconsideration.
That is correct.
And when does the time frame for reconsideration, in theory, expire?
The commission has extended the 20-day deadline that's in our rules for deciding a motion for reconsideration. So at this point, there is no terminal end date that we must decide a reconsideration by, though I am and staff is working on finalizing a memorandum on reconsideration, which will be presented to the commission as soon as possible. And we're working to present it at next week's business meeting.
Okay, thank you for that clarification. I'm going to oppose the motion. I would grant the motion to stay, pending disposition of the motion for reconsideration. I would import the standard set forth in Montana case law, such as Cole versus St. James Healthcare 2008 MT 453, which says that the purpose of injunctive relief, such as a stay, is to maintain the status quo pending the final outcome of the controversy. Part of maintaining the status quo is restoring the parties back to the last peaceable action before the controversy arose. In this situation, the last feasible action would be that M2 roll-offs did not have authority to operate, and that the existing incumbent carriers did have the authority to operate. I do believe that ultimately, if this commission is found, as I have stated in my dissent filed in this matter, to have erred as a matter of law in this matter, then we are going to have irreparable harm both to the incumbent carriers and to the public in the form of allowing a entity to operate unlawfully. I will not have support for my motion, so I'm not expecting the same, but I would state my position at this point. Thank you, Mr. Chairman.
Thank you. I would comment on President Brown's reference to maintaining the status quo. I should think that because this commission has allowed applicant to operate and is, I believe, operating, that the status quo is that they have entered into business contracts at this point, and by offering issuing a stay would be interrupting the business operations that we have allowed to initiate, and that would be disruptive and contrary to the public good. So I would I appreciate very much the President's comments, but in this reference to the status quo, I think it's the status quo is the current state of business, not the previous one. Although I appreciate his point of order in the law as to what that means. President Brown.
Generally, as you know, when I chair these meetings, I try to discourage debate on this, but I would just like to point out, as I understand from Ms. Webster, that the standard that is adopted by the commission is a two-factor test. One is whether a stay is reasonably necessary to protect the protestants from serious harm. Is that correct?
President Brown, that is what staff recommends the commission consider here.
Okay.
First.
The word applicant is not contained in that statement, is it?
It is not.
Thank you. And the second factor is whether a stay is reasonably necessary to prevent imminent harm to the public, correct?
Correct.
Is the word applicant in either of those two-part tests?
No.
Just like that clarified for the record in this matter.
Very good. Any other comments? Vice President Fielder?
No comments.
Very good. Let's call for a vote then. Oh, pardon me. Oh, yeah, please. Yeah.
Mr. Chairman, Chairman O'Donnell,
Thank you.
I think with your comments about them already doing work with people they have contracted with, I think that addresses the potential imminent problem for the public. And I'll be supporting your motion.
Thank you. So no further comments. Let's move to a vote on the issue. All those in
Hold
favor?
on, I request
Sir?
roll call vote, please,
Yes,
because I
absolutely.
suspect litigation is coming.
Okay, so we'll move to a vote then. Roll call vote has been asked for. Vice President Fielder,
Aye.
Commissioner Bukacek,
Aye.
Vice President President Brown,
No.
and Commissioner Pinocci. And I vote aye. So the motion passes 3-2. And I see no other further business of this commission. Our next scheduled meeting is 1 week from today at 9:30 in this room. That would be the 17th of December of 2024. The meeting is adjourned.